Essay 5, the last essay of the July 2024 California Bar Exam. We're in the second hour of a 3.5-hour session in that exam. Have to keep it down to 1 hour because we need to save 90 minutes for the PT. I see 2 calls. What damages can Perry recover? What equitable remedy or remedies can Perry recover? So this is a straight remedies question. They're not asking rights and remedies. So the cause of action has to be in the hypothetical. I look right above the calls of the question and I see Perry filed suit against her for fraud. The court has ruled in Perry's favor. We need remedies for fraud. Let's stop here and take a look at what I would have memorized and organized in my mind, in my active memory, as soon as I realized this was remedies for fraud. So I'm going over to Proponics. That's our software platform that holds all of our outlines, the things we memorized for the bar exam. And I'm going to remedies. I'm going to tort remedies. Fraud is a tort. And here we see damages, meaning legal remedies. I have general principles that everybody knows: causal, foreseeable, certain, unavoidable. And the purpose of tort damages is to make the person whole. Everyone knows all these general principles. We're given fraud though, so I need to think about punitive damages. I'm probably going to want to argue for punitive damages, and that's a much more complex analysis, particularly after Campbell. In order to decide whether punitives are justified, we have to look at the reprehensibility of the defendant's conduct, and there are factors that the court has set up to do that: physical versus economic, reckless disregard versus indifference, repeated actions versus isolated incidents, intentional malice or trickery or deceit versus just an accident. So I'm looking for facts that go to those factors. If they're justified, then there are limits to what will be awarded. And generally, it has to be single digits. Generally, no more than 4 times the amount of the damages award. So that's the analysis for punitives. But, okay, this is just legal remedies. What about equitable remedies? Let's look at restitution and think about injunction. And I'm not going to go into great detail about injunction, but look at all the things I can argue under restitution, and I would have this all memorized. I can argue unjust enrichment. I can argue for replevin, to recover specific personal property acquired or held unlawfully, plus damages for lost use. I can argue detinue. What's the difference between detinue and replevin? Detinue is recovery of personal property belonging to the plaintiff that was acquired lawfully by the defendant, but now held unlawfully. What else can I argue? I've already got in my mind unjust enrichment, replevin, detinue. What about the big ones? Constructive trust and equitable lien. Constructive trust. It's where the court imposes an obligation on the defendant to convey specific property to the plaintiff. There are 4 elements. Defendant has title, acquisition is traceable to wrongdoing, unjust enrichment, and no adequate remedy at law. The benefit of a constructive trust is that the plaintiff gets any appreciation in value, and the defendant has to transfer title and possession. An equitable lien, on the other hand, the elements are that the wrongdoer has title. He has misappropriated the plaintiff's assets. Assets can be traced into either acquisition of title or improvements. Retaining the property creates unjust enrichment. The benefit of an equitable lien is that with an equitable lien, the plaintiff can get a deficiency judgment when the value of the property has decreased, a deficiency judgment for the balance of the claim. And of course, we may need to think about an injunction. Sometimes the facts take us there. Other times the major issues are equitable lien and constructive trust. But if you've studied for the MBE, you know that there are specific things we need to know for specific torts about remedies. So let's go there for more detail. And let's find fraud. There it is, near the bottom of the list. What do we need to know about damages? Well, there's a distinction between tort and contract there. In contract, of course, it's going to be the benefit of the bargain. What about restitution? What's the detail under restitution? That generally is going to be a constructive trust. And the only special note I have to myself under injunction is that equity will not enjoin a crime. So with all that in mind, let's go back and look at what they've given us in the facts. We've got that years ago, Perry purchased 2 baseballs that he understood were autographed by members of championship teams. One baseball was signed by the Junction City Jaguars team, and another was signed by the Small Town Sluggers team. Because Perry knew nothing about the value of these baseballs, he entered into separate contracts with his niece, Denise, a sports memorabilia expert, to sell each of them. I keep reminding people that on the California bar, the plaintiff is a P name, the defendant is a D name. Helps you remember who these names are. Aware of Perry's ignorance of the value of his baseballs, Denise told Perry that the Jaguars baseball was a counterfeit worth only $20. Why did they tell us aware of Perry's ignorance of the value of the baseballs? Well, in part because that goes to deliberate trickery. She knows he's ignorant. She's going to take advantage of it. That's part of your analysis in punitive damages. As I said, the call is about remedies, so I'm not going to go into detail about fraud in my answer because that's non-responsive. As a result, Perry sold the Jaguars ball to Denise for $20. In fact, the Jaguars ball was worth $5,000 on the open market. So she has defrauded him out of what? $4,980 right there. Denise told Perry that the Sluggers baseball had a fluctuating value and that it could sell for at least $1,000 and likely more. Denise sold the Sluggers baseball to Bob for $10,000, but told Perry that it had only sold for the $2,000 she gave him. Notice how different this is from what she did with the other baseball. With the other baseball, she lied about the value. Here, she didn't lie about the value. But she cheated him out of $8,000 because she sold it for $10,000. She gave him only $2,000. So again, intentional trickery, intentional deceit. With the remaining $8,000 that Denise received from Bob, she purchased a used Voy car. All right, so she has changed the form of title here from the cash to a used car, to which she at this point has title. Ironically, since Denise purchased the Voy, interest by collectors in Voy cars has vastly increased, and her Voy is now worth $20,000. Remember, the effect of a constructive trust is that the plaintiff gets the appreciation. So what a great remedy that would be for our plaintiff. He'd get $20,000 instead of the $10,000 that it sold for, because he'd get the appreciation on the car if we can meet the elements of a constructive trust. Denise still has the Jaguars baseball and the Voy car. After learning of Denise's deception concerning the baseballs, Perry filed suit against her for fraud. The court has ruled in his favor. Okay, call 1 is legal remedies. So use your facts to analyze legal remedies. Let's go after damages. And of course, I have to talk about how the damages are causal, foreseeable, certain, and unavoidable. And I think you can pretty quickly establish all of that with these facts. So for general damages, on the Jaguars baseball first, it was worth $5,000. He got only $20 for it, so the general damages would be the difference between $5,000 and $20,000, or $4,980. On the Sluggers baseball, it's trickier. She gave him $2,000 for it. She got $10,000 for it. So on the surface, it looks like $8,000 is a perfectly fine legal remedy. But we aren't given its open market value. We're just told that it's more than $1,000. So I'm going to argue that that amount is speculative, that that's not an adequate compensation because we don't know how much it's worth. It's a fluctuating value. It depends on what a bidder would be willing to pay for it. That argument will set me up to ask for a constructive trust, because remember, one of the elements of a constructive trust is that the legal remedy is inadequate. But then we need to think about punitive damages, and we need to think about those factors that go into the decision about how reprehensible this defendant's conduct was. It was purely economic harm. It wasn't physical harm. That weighs against the plaintiff getting punitives. But she showed reckless disregard versus just indifference. We don't have really any facts that go to financial vulnerability. Repeated actions versus isolated incidents. Well, I guess you could argue that the two frauds here, the two baseballs, represent a repeated action. Intentional malice or trickery, yeah, you can show that. She knew that he was ignorant of the value, and she did this quite deliberately. It was intentional trickery, intentional deceit. I don't think it matters which way you come down as to your conclusion on whether this plaintiff will get punitive damages or not. My preference would be to find that he would get punitive damages because it was such intentional deceit. But I don't think you would suffer in your score no matter which way you came down as long as you analyzed it. And then we need to think about call 2. Equitable remedies. We need to think about restitution and injunction. And I'm going to tell you right off the bat, I wouldn't spend a huge amount of time on the injunction analysis because you have so much to have to analyze under restitution. So I would do a quick injunction analysis to tell the grader that he could likely get an injunction to prevent her, a preliminary injunction, maybe even a TRO, to prevent her from doing anything with that Jaguars baseball until he gets it back. But they gave you a lot of facts in that paragraph I just marked, the third paragraph, that go to constructive trust and equitable lien. So think about all the issues under restitution. You can go after an unjust enrichment theory. You can go after replevin or detinue, I suppose, because it's personal property that, although she acquired it lawfully, she's now holding it unlawfully. She cheated him out of the most of the value of the baseball, and he wants it back. So those are remedies I would want to cover. But mostly I want to spend my time on constructive trust and equitable lien. For constructive trust, we need to show that she has title to the property. She does for one baseball, and she has title to the car for the other baseball. Yes, she's changed the form of that property, but she has title to the car. People frequently misunderstand about constructive trust. As long as she has title to property that she acquired using that original property, you can go after a constructive trust on it. Acquisition of that car is traceable to the fact that she cheated him out of the most of the value of that baseball. She would be unjustly enriched if she were allowed to keep it. The problem with constructive trust often is demonstrating that there's no adequate remedy at law, which is why I would look at those facts and argue that we don't know what the value of that ball is. It would depend on what it would sell for at the time at auction. And so a legal remedy is going to be inadequate. That would allow me to get a constructive trust over the car, and as I said earlier, the benefit of that is that then Perry gets the whole value of the car. Perry gets appreciation. In other words, he would get $20,000. So I know this is a bit of a diversion from this actual fact pattern, but think about what a constructive trust is. It's a sort of a fiction by the court that says the property you're holding you actually held in trust for the plaintiff. When a hypothetical asks you for trust-based remedies, think about constructive trust. Sometimes a California bar hypothetical will do that. The call will be literally framed that way. What trust remedies are available to this plaintiff? And people tend to forget about constructive trust. Their mind immediately goes to their wills and trusts course and what the remedies were there. Back on track with this hypothetical, equitable lien. The elements are that the wrongdoer misappropriates the plaintiff's assets. She did. She misappropriated $8,000 of the value of what she got for that baseball for him. Now, she doesn't have the $8,000, but the form of that got transferred into the car, and she has title to the car. His assets can be traced into acquisition of title, the same way we did in constructive trust, and retaining the property creates unjust enrichment for her. We can meet those elements, so equitable lien is also a remedy that would work. It's usually the preferred remedy when the property has decreased in value. Constructive trust here works beautifully because we can show that the legal remedy is inadequate. That's a lot of issues to cover, but if you have an organized framework and know this well, it's possible to write all that in an hour. Now, we've reached the end of this, and I need to know something from you. Would it be of value to you if I debrief the performance test from this exam? Putting these videos out is sort of like speaking into a void. I'm not hearing from many but a handful of people. So if you would like to see a debrief of the performance test, and if you're watching this on YouTube, then please leave a comment for me telling me that you would like to see that PT debriefed. And of course, make suggestions for anything else that would help. People always ask me if the outlines that you see, the schemas you see me using in the midst of these debriefs, are available in electronic form? And the answer to that is that they are, but not in files that I can send you. They are in a software platform that's accessible through Power Law or through a Pure Proponic subscription. If you're on YouTube, I will put the link to Power Law, to the plans, below in the description. Thanks for sticking with it to the very end of this video, and help me out by subscribing and putting a like on the video.